Okay. Hello, everybody. Thank you for attending this course on intellectual property. This is the first session of the second year of this course. It's a specific training on intellectual property and technology transfer held by the IUSS School in Pavia. The first two sessions will be held today, the first by me, Luigi Cristiano, and the second will be held by the Dr. Jacopo Fanti from the University School of Bologna. First talk will be on the juridical aspects, the second on the prior art search. First of all, a short introduction to intellectual property. When we talk about intellectual property, we can use this scheme. Okay. But you can see the knowledge base. So starting from general principle, the ideas, we can split two sides of the pyramids. The first regarding copyrights on the left, the second regarding the patents on the right. So we start from the basic knowledge and the public domain to arrive to the applied knowledge regarding copyright and to intellectual property when we talk about patents. So not just the ideas, but a creation with an aesthetic content when we talk about copyright, and a creation with a technological content when we talk about patent. We have some exceptions, like the free use and the invention non-patentable. We will talk about the non-patentable inventions in the following slides. And this is a general scheme where you can find the knowledge domain of intellectual property. The term intellectual property refers to all rights that included the moral rights and the economic exploitation of the results. This is because the moral rights can be recognized to the author of the work or the creator of the patent, the invention, and are personal and non-transferable rights. So they can't be sold. The economic exploitation, otherwise, is a transferable and unavailable right. You can sell it, you can share it, you can renounce it. So this is the economic exploitation. The industrial rights, the industrial property law, is structured in legal instruments, in tools. These tools allow intellectual property to be exploited on the market under some condition, but there are only a certain limited number of industrial rights. So not everyone and not everything can be protected through the industrial property law. The basic rule, and it's a European rule, is the free competition. We have a lot of regulation about the general rule is free competition. The industrial right is an exception. We can use industrial rights, industrial property law, under certain conditions. The intellectual property universe is a wide range framework of tools for protecting your ideas and your creation. This is nowadays all the tools regarding intellectual property. Yeah, copyright, okay. And these are all the tools. We have some different types of intellectual property. like patents, utility models, copyright, trademarks, registered design, and trade secrets. There are 2 slides. Patents are granted for technical inventions. The application for patent are examined by the patent office, and they are filled with in order to determine whether they meet the requirements for a patent to be granted. The patents generally last for a maximum of 20 years from the date of filing, and they're the most famous form of IP protection. The utility model offers a simpler protection for a shorter period of time, but they are usually more published and more registered and in a quicker way, in a faster way, instead of patents. The copyright, differently from patent and utility models, doesn't need to be registered. The copyright automatically exists when a work is created. Copyright protects any type of original, creative expression, including the most famous are literature, drama, art, music, photography, broadcast, recording. The other types of IP, trademarks, registered designs, and trade secrets. Trademarks are the distinctive signs indicating the search of a product or a service, or maybe the name of the company, the business company. They can include, for example, the names, of course, the logos, the images, but also the colors applied by the owners, and the shape of the wording of the font. Registered design protect the external appearance of the product, and they don't give any protection for the technical aspects. They include new patterns like ornaments, shapes, texture, and they need to be original, and they need to have a individual character distinctive of their own. Also, the artistic aspect of a design may be protected by copyright. So you can protect a registered design and use also the copyright protection. Designs could be also unregistered, and they enjoy some protection, some sort of protection. A registered design is obviously free, and it's an automatic right that you get when you present a design to the public. So it gives you the right to stop anyone from copying your design, the exposure to the public. The protection, of course, is of an unregistered design is limited in time respect of a registered design. Trade secrets. Trade secrets cover the information that are not known by the public. If you own a trade secret and you are careful to keep it confidential, you can sue anyone who steals it. So you can see in the images, the secret is as not an example. Coca-Cola is a registered design. Trade secret is just silence. In one single product, we can find many IP rights, like the trademarks, the name Nokia, the product, 1920x1080, the tone, the startup tone. We can see in the following slide, the trademark could be also a sound, a music. We can protect with copyright, software, of course. We'll see then why software is protected by copyright and not by patents. The user manual, of course. The ringtones, they are musics, the startup tone, and also images. We can protect the same product using patents and utility model for data processing methods, the operating system, and the user interface. Also the design, the form of the overall phone, the shape, the button. The first iPhone protected the shape and the button, the central on button, and also the position and the shape of the screen. Last but not least, the trade secrets. You can protect some technical know-how. Choose not to protect it with a specific tool, but just not share it in the public domain. Without the intellectual property, many innovation projects will not be profitable because anyone could copy your idea, your invention. These are some examples of innovation that has been protected and exploited by the inventors. The first one is the Sandvik AB. It's a Swedish developer and manufacturer tools and machinery. They sell their product in 150 countries. And in 2012, they were named as one of the world's 100 most innovative companies. They have a subsidiary company, the Sandvik Intellectual Property AB, and they holds and manages 8,000 patents. So this is their real business core, managing patents. Another example is the ARM Holding. It's a British multinational semiconductor and software company. If you work in the computer field, maybe you heard about the ARM Core, ARM CPU. These are all of it are. Okay, could you turn off your mic, Roberta? Thank you. All of these CPU core and computer parts are designed and protected by the ARM Holding. Another example is the Gore-Tex. The WAL Gore and Associates was founded by the Gore family in late 50s. And they developed an high-tech products based on a new polymer. And they create a breathable fabric, you know, the Gore-Tex fabric, that is both waterproof and windproof. The last one is the Dolby Laboratories. They use a combination of patents to protect their technology, specifically their noise reduction technology, and they associate the technology to their trademark. The Dolby trademark, Dolby Digital, Dolby Atmos, they all register trademarks. It's interesting talking about the Dolby. They are, of course, inventors and manufacturers, but the 86% of their revenue is from the licensing technology. So they grant the most of their money from the already existing patents. They license the patents to others, and they gain money loaning their patents. These are an example, like the general public license by Linux or the Creative Commons. These are typical form of protection of software or operating system. And also some example from the Free Trade International. It's an industry that fair trade products coffee, and they choose to run for the public benefits rather than for the profits. So they license their trademarks, Fair Trade International, only to those companies who agree to sign a certain environmental and or ethical criteria to grow their coffee. So how does it work, the IP? Whenever a new product is successful on the market, it's very likely that competitors will attempt to make a similar or maybe an identical product. So the innovator will probably have invested a significant amount of money in developing the new product to create the supply chain for the production and for the distribution. And maybe he's running also marketing campaign, or is finding partners for the distribution. So the competitors can benefit from this effort. They have, of course, a greater market access. Maybe they have already a better connection with distributors, and can access to cheaper primary resources. So they are able to offer their products at a cheaper price. So the innovators are under a heavy pressure, and they may be driven out of business, for example, while the competitors could have a free ride on the back of their creativity. So the IP system helps the innovators to protect their invention, their design, their brands, their trademark, their artistic work, and so on. And of course, the IP system provides them with ownership over their work. And the IP system grants to the owner the rights to exclude competitors from the production, from importing or the sale of the goods created by the inventor. So let's see the different tools, the different kind of IP protection, starting from patents. A patent is could be considered as a contract between the applicant of the patent and the entire society. The applicants and the patent owners are interested in benefiting personally, of course, from their invention, and they have the right to prevent others from making, using, offering for sale, selling, importing, distributing a product that could infringe their patents. of course, for a limited amount of time, and only in certain countries, the states for which the patent has been granted. The exception to this use for non-commercial purposes, for example, if you use for a private use or academic research, this could be an exception to patent protection. Why does this agree between society and the investor, the inventor? The society is interested in encouraging innovation so that better products can be made and a better production methods can be used for the benefits of all the society. Of course, it is interesting in protecting the new company so they can be competitive with the larger one, in order, of course, to maintain a competitive economy. So if the big company destroy the market of the new company, there will be, of course, the monopoly. In return for the protection, the applicant has to reveal his invention to the public, so the other can build on it. When you file a patent, you told everything about your product, about your invention, and the patent is public. So anyone can see the patent, can see the technological information about your invention, and they can, of course, create your products and sell them, but they can build on your invention, on your product, on your research. The patent will be published after 18 months. So when you file a patent for 18 months, it will be secret and then will be visible to everyone. What can be patented? According to the European Patent Convention, an European patent shall be granted for any invention in the field of technology that are new or involve an inventive step and are susceptible of industrial application. So they have to be new, there's an inventive step, and they must have an industrial application. So not just theoretical idea. New to the world means that there should have been no previous public disclosure of the invention before the date of the filing. The inventive step is the real problem of the invention because it's quite difficult to assess. And the European Patent Office compares your invention with what would have been obvious to an imaginary person skilled in the art at the time of filing. So they imagine that your invention could be acquired, invented by a person who has the skill in this particular field. So like an engineer, if you are talking about an invention created by a mechanical engineer. In most countries, patents are not granted for the business methods or rules of games. So like method of treatments, diagnostics, surgery, and human or animal body, of course. In fact, the European Patent Convention does not define what an invention is, but it provides a non-exhaustive list of subjects and activities that could not be considered invention. So like the human body, the animal body, diagnostic method and surgery, etc. Second tool, databases. What is a database? A database is a collection of independent works or a collection of data or other material arranged in a systematic or methodical way and accessible by electronic or automatic methods. Independence work means that they should be separable from one another without their information with artistic value, with our musical or ideas could be affected. So a database is a collection, for example, of artwork, a collection of Tintoretto will be a database. If you split the 50 artwork of Tintoretto, the database is gone, but the single artwork maintained its value, its artistic value, and of course, its economical value. Arranged in a systematic or methodical way means that the material should be contained in a sort of base, a fixed base, and should include technical means such as electronic, electromagnetic, electro-optical, index, table of contents, plan methods, classification methods. Databases are protected in Europe on the legal protection of databases. In particular, we talk about sui generis protection, or in some cases, copyright protection. A database can be copyright protected work if the arrangement or the selection of the content is the author's own intellectual creation. So the creation of the method of the selection could be protected by copyright. The only relevant requirement is the originality. So if this arrangement, this selection, this content order is original, could be protected by copyright. In addition to this copyright protection, the Database Directive introduces also a sui generis rights to protect the specific investment made by the database maker. So the creators have to show a quantitative or a qualitative investment in obtaining their database, and they gain the exclusive right to prevent others from extracting and reusing or the database or part of it and part of the content. In this protection are excluded the computer programs because they gain the protection under the copyright. So a software can't be a database. Of course, there are limitations regarding the databases. The first exception to database rights are the purpose of the access to the content for the normal user, or the reproduction for private purposes, the use for the illustration, or for teaching, or for scientific research, or for public security reasons, public intent generally, and some specific exception could be provided by the national law. When we talk about databases, the protection is shorter than the patents because it's limited to 15 years. It can be extended, changing database results in a new term of protection. Trademarks. A trademark consists of any sign capable of distinguish goods or services or firm or company names from the others. Trademarks serve to indicate the commercial source or the origin of the products or the services, or may fulfill a function for advertising, for example. In the European law, the signs, the trademark, have to be signed able to represent it in the European Union Trademark Register. So the elimination of the geographical representation from the old directive created the European trademark. Trademark must be distinctive. The first problem for the trademark is the lack of distinctive character. So if it isn't distinctive, it will be refused by the European Patent Office. Other motivation for the refusal are the for example, if the sign is contrary to the public policy or violates principles, state principles, or morality. In this case, there's a really recent case. It's the last, it was in 2022 in Italy. There was a trademark for an alcoholic drink, a gin. The creator called it vagin. So sounds similar to the Italian word vagina. That's the feminine genitals. And the patent office refused the registration because it violates the morality. In this case, the owner filed an opposition according to the existing mark in Italy, like Grappa Bocchino, for example. So they won the opposition and they registered the trademark because the office granted the distinctiveness of the sign and the not violation of the morality, Italian morality. How can you register a trademark? You can apply for a national trademark, for an international trademark, of course, or for a European trade union mark. National trademark is possible in every nation, I think, but the trademark is valuable only in the territory when the application is filled. So the European Union trademark protects your sign in all the European market. So that's the better way, I think. it's possible, of course, to file an international application with the WIPO, the World Intellectual Property Organization, so you can apply for a world trademark. The scope of direction for the trademark is to gain an exclusive right to prevent others from using your mark. The exclusive right offered by the trademark is directly linked to the specific good or service they are registered. Of course, the first limit is the territoriality. The trademark is limited to the territory where the mark is registered. But unlike the other IP rights, the trademark can be renewed indefinitely. So 10 years by 10 years, you can protect your sign forever. For the patent, for example, you can protect it for 20 years and then it's public. So you can protect it again. The trademark could be protected all life long. Designs. A design is the appearance, the outward appearance of the wall of your product or a part of your product. The product could be industrial or handcraft. There's no difference. And the example of design could could include lines, colors, shapes, packaging, logos, for example, the Coca-Cola bottle. There are just two requirements for the protection. The first one is the novelty. So the design must be new and no other identical design should have been made available in public. And the second is the individual character. The requirements of the individual character is not met if another design which creates the same overall impression of the on the informed user has already been disclosed. Of course, there are some exclusions like public order and morality, also in this case. And the design could be registered or unregistered. It's possible to file a registration for a design at national, international, or European level. So the international registration is held by the World Intellectual Property Organization. The European registration is filed in the European Intellectual Property Office. But the protection in the whole Europe is possible also without registration. This takes the form of the unregistered community design and can be useful for products that have a short lifespan, for example. So the registration form, the registration process in this case could be longer compared to the length of the design or the product. So if I create a product that change its form, its shapes every 6 months, 1 year, protect the design will be difficult because of the time necessary for the registration. The scope of protection for the designs is a wide and includes the reproduction of the design, but it's limited to the territory. The copy. And just for 3 years, when we talk about a registered design, or 25 years for the registered design. A registered design real can be renewed for 4 times, so you can gain up to 25 years. So this is the maximum amount of time. Geographical indication. A definition of geographical indication is provided by the TRIPS agreement. And it's the definition written in the slide. So geographical indications identify a good as originated in the territory of a country or a region or a locality in the territory, where a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. In Europe, we have a distinction between protected geographical indication, PGIs, in Italy, IPG, and protected designation of origins, PDO, or in Italy, DOP. Various regulations in Europe allow the registration of geographical terms for wines, spirits, alcoholics, drink, cheese, for example. So not just agricultural and agricultural products, but also foodstuff, food generally. The difference between PGIs and PDO. PDO is has a stricter requirements than the PGI. In the case of the PDO, the qualities or the characteristic of the product must be essentially or exclusively due to a particular geographical environment within our natural and human factors. By contrast, a geographical term can consider the PGI when the product's quality of reputation is attributable to its geographical origin. Secondly, the protection as a designation of origin, so as a PDO, is only possible when all the stages from production of the raw materials to preparation of the final product take place inside the defined geographical area. For the PGI, it's sufficient if just one of the stages is situated in the geographical area. So for a DPO, you have to create your product. The entire process should be held in the geographical area. For the PGI, you can grow the grape wine in the geographical area and product the wine in another one. Utility models are intellectual property rights that protect the technical invention, like a patent do, but differently from the patents. Utility models are available in some countries, like China, for example, Japan, but not in all the countries. For example, Canada, UK, and United States doesn't recognize the utility model. The application for a utility model must be filled in the country where the applicant is looking for the protection of his invention. And of course, because of the particular territoriality of the utility model, there is no European or international utility model. Depending on the different legislation, utility model can be protected for up to maximum 10 years in most of the country. On the contrary, the patent could be protected for 20 years, as we've seen previously. In most countries, utility models are registered without any examination, so there's no control step by the patent office. These are the principal difference between utility models and patents. So utility models and patents are both registered territorial rights, offering protection for technical invention, but in contrast to patents, utility models are only available in certain countries, must be filled individually in each country, and offer protection for 3 to 10 years, while the patents, of course, for 20 years. Utility models are normally registered without a search or a report or prior art, and in the next talk, we'll see the prior art, what is, and are normally registered and published in a few months, while the patent application are normally published after 18 months. And the application of the patent application is a procedural step prior to examination of the applicant. In general, utility models are registered without examination as novelty, inventiveness, industrial application. The validity of the utility models with respect to novelty and incentive step is only reviewed in a revocation or infringement proceeding regarding to other utility models. That's okay. So in some cases, the biggest advantage of filling a utility model is often the speed with which it is registered, because there's no examination. They are more faster than the patent application. Last one, I think, is the plant variety. Plant variety rights give the holder the exclusive right to exploit a new plant varieties. A plant variety can be protected if it is new, distinct, uniform, and stable. The person who is entitled to the exclusive right is referred in the legal text as the breeder. So the owner, the right holder, is the breeder. And the breeder can be the person who bred the variety or the employer of the person or the company who bred the variety. Plant variety rights are obtained through the registration at the national level or international level, and also at European level. In European legislation, the protection cannot be shorter than 20 years. In some cases, like vines and trees, the minimum term is 25 years, so 20 or 25 in some cases. The breeder has the exclusive right relating to the propagating material and the harvested material. The propagating material is the reproductive or vegetative propagating material, so seeds. The harvested material is material obtained through the unauthorized use of propagating material. Some acts like relating to this material require the authorization of the breeder, like the production or the reproduction, the multiplication of the plant variety, and the exclusive rights of the breeder are limited, done for certain purposes without his authorization, like the private and non-commercial purposes, experimental or scientific purposes, and the purpose of breeding other varieties. Semiconductor typography. Semiconductor integrated circuits are embedded in a wide range of electronic devices, such as computers, mobile phones, television, all of your electronic devices. And the size and the performance of the circuits is determined in part by the layout design. So it's a particular type of product. They have an invention characteristic, an inventive characteristic, and of course, a design specific layout. It's because a semiconductor consists of some layers which are composed of semiconducting material. So the typography is the design of the pattern. The layout design creates a three-dimensional arrangement of the layers and, of course, their connection, their interconnection. We can skip this information. Okay. The semiconductor topography rights give the owner the exclusive right to exploit the specific design, the layout design, for commercial purposes. And some countries have a specific and different law for these rights. The duration of the protection is for a maximum of 10 or 15 years from the date of creation. And there are a lot of exceptions and limitations to this protection, like the private purposes or the reproduction for the purpose of evaluation, analysis, research, or teaching. It's permitted the reverse engineering by a third party in some cases for the purposes of examination. And in case of reverse engineering, the third party would use the information to create a new original layout. So I can study the registered layout and create my own. Copyright. Copyright is a different kind of protection because it doesn't protect a technological invention, but any production of the human mind, provided that this production is an expression of the idea and not a mere idea. So the expression should be original, has to be an aesthetic innovation, creation. So example of the copyright protected work are the artistic, literary, scientific paper, musical, sounds, music, photography, computer programs. The period for which legal protection is granted is a term of minimum of 15 years after the author's death. So not from the registration, not from the creation, but from the author's death. In the European Union and in most of the country, also in the United States, for example, the period is extending to 70 years. So for 70 years after the death, the author's death, copyright shall be granted to the authors and to the sons, for example, when the author is dead, sons and nephew of the author. Copyright confers both economic and moral rights to the owner. The economic exploitation include the rights of the reproduction, communication to the public, the translation, the adaptation, distribution, resale of the artwork. And the moral rights include the rights of authorship, integrity, and divulgation. Last, trade secrets. This is not a specific tool granted by law, because there's no legislation, specific legislation. We have some provision in the Italian Civil Code, but trade secrets must not be known or discoverable. So the tool is to not share your secrets, your information, but they must have a business value, a commercial value or economic value provided by these secrets. And you have to demonstrate that a reasonable effort have been made to maintain the secrecy of the information. Trade secrets have no period of duration. Trade secrets are valid for as long as they remain secret. So, for example, the Coca-Cola recipe is nowadays a trade secret, but the creation is in the late 18th century. So it's 150 years, more or less, and it's nowadays a trade secret. The protection of the trade secrets involves both practical arrangements to restrict the access to knowledge, and also legal or contractual arrangement to ensure that those who have access to the secret or the confidential information do not share it with other parties. In many countries, there is unemployment agreements that include restriction on the information the employees may not give to the competitor. And of course, non-disclosure agreements are a typical form of trade secret protection. So we sign an agreement where the parties agree that the information shared between those two parties will be not shared with another party. These are the general introduction to the to the intellectual property. So let's see some specific provision regarding the Italian IP law. This is the Italian IP regulation framework, starting from the Directive 95 of 2008, and so on. Some provision in the Italian Civil Code law, as we stated before, but the most relevant document is the Italian Legislative Decree 2005 number 30. It's the so-called Industrial Property Code, and also the Italian Copyright Law number 633 of 1941 regarding the copyright and the rights related to the commercialization of the artworks. There are some restrictions to the rights, generally speaking. In particular, the relativity of the protection. So the exclusive reservation of the exploitation of the sign or the invention has been limited within the same sector or the inventional idea in which the owner operates. So I can protect my invention or my sign, my trademark, in all the fields or economic fields, but I have to choose in which field, in which sector I want to gain this protection. I can gain the protection in every field of knowledge, yes, but it will be really expensive, and third party could be feel in a position because there's no reason to use a trademark in every sector of the human knowledge. Because if you use the trademark Coca-Cola and your business core is the non-alcoholic drink production and distribution, there's no reason to protect your sign, your trademark in the aerospace sector or in geographical indication or plant variety, okay? Territoriality, of course, this is the most relevant limitation regarding the territory. And of course, the limitation of time. This is the European Directive on the Trademark regarding the exhaustion of the rights conferred by the trademark. So the trademark shall not entitle the proprietor to prohibit its use in relation to goods which have been put on the market in the community under the trademark by the proprietor or with his consent. So I create the first Coca-Cola bottle, I sell the bottle to a grocery, and the grocery sell it to a person. I can't act for a rights violation if the person who acquired the bottle used the Coca-Cola brand, because the expiration of the trademark rights has been with the sale, has been in the moment when I sold the bottle, when I put on the market the first product with the trademark Coca-Cola, for example. So the copyright ends with the first sale, like for a book, for a CD. In the Industrial Property Code, we have some provision about the acquisition and establishment of the rights. The industrial property rights are acquired through patenting, registration, or other methods provided by the code. Inventions, utility models, and new plant varieties may be patented. Trademarks, designs, and models, and topographies, and semiconductor products may be registered. Distinct marks, other than registered trademarks, confidential business information, geographical indication, and designation of origin will be protected. And that's all. So we have the creative intellectual works in the copyright law, the distinctive signs in the civil code and industrial property code, and technical and design innovation in civil code and industrial property code. What can be protected? Statement from the Article 1 of the Industrial Property Code. The expression industrial property includes trademark and other distinctive marks, geographical indication, designation of origin, designs, models, inventions, utility models, topographies of semiconductors products, confidential business information, and new plant varieties. So this is our Italian industrial property rights. As you can see, the Italian legislation includes the confidential business information, so they are protected by the law. That is not the same for all the countries in the world. In particular, we gain protection to patents when the invention meets the following requirements: novelty, inventive step, inventiveness, industrial application, lawfulness, sufficient description, and the subject matter does not extend beyond the content of the field application. So you have to provide a sufficient description. If it is insufficient, the patent will not be granted. And of course, must be lawfulness. In addition, in Italy, we have the right to protect the utility models. And the difference is, in particular, from the type of inventiveness. So the invention will be protected by the patents, and they have to be new and original solution to a technical problem. Utility models could be not only a new and original solution to a technical problem, but new product configurations, providing particular application or convenience for the use of machine, of a part, a tool, an object. In the utility model, you have a less detailed description and a shorter duration. An example, a concrete example. This is the patent for the first cell phone. It is it met some requirements. The novelty, there was no other mobile phone. The inventive step, it was no obvious. The industrial application, of course, we have a cell phone. The lawfulness, it was lawful to create and to use a cell phone. And a sufficient description. On the other side, the utility models, this is a particular window. So a window is could be a patent because I create a solution to a technical problem. how to illuminate a room without closing the wall and protecting from cold, for example. If I change the design of the window, I create a Basistas window. So this is a particular application, particular conformation of the object. Of course, in Italy, we can protect the trademarks on the Article 7 of the Industrial Property Code. The protection is attributed to trademarks that meet the novelty, distinctive character, and the lawfulness. A trademark could be not just a word, a name, but could be also a drawing. They could be letters, numbers, a combination of letter, numbers, images. Could be a shape of a product, like the Coca-Cola bottle. The design of the bottle is a protected design, but also the shape of the bottle is a protected trademark. So when you see the Coca-Cola spot on TV, the advertising on television, you can see they draw the shape of the bottle with the logo, with the Coca-Cola logo, because the shape of the bottle is a trademark of Coca-Cola company. But also a sound, for example, a shade. We can protect also a domain name. The domain name is the internet address for which a site can be reached. www.iuspavia.it is the domain name of the IUSS school. And the Industrial Property Code recognizes the domain name as a distinctive sign. So in a certain condition, it could be considered an unregistered trademark. So you can use your domain name for the pre-existence procedure or opposition. So if I register the domain name, for example, www.armani.it, I can gain a pre-existence of this trademark. So there's been in the past years a real juridical controversial regarding the Armani domain names, because an Italian company, Armani Timbri, registered the trademark, the domain name, before the haute couture Armani company. So the Armani company, the stylist act for the acquisition of the domain name armani.it. We can protect in Italy the design when they met the novelty, the individual character, the lawfulness, and a visible feature that is not determined solely by its technical function. So, for example, the form, the design, like the texture, a typical design or model registration could be for design object, like some particular chair, the Basili chair, or some sofa, like the mouth, the sofa of Dali, or some designs for textile, like the Missoni designs for fabric. We can also protect biotechnological inventions for 10 years duration, but we can protect through patenting biotechnological invention the human body, the inventions whose commercial exploitation is contrary to human dignity, to the public order, to the morality, to the safeguarding of health, and to the environment, to the life persons and the life of animals, and also to the preservation of plants and biodiversity. Of course, the copyright. We can protect through copyright literary works, cinematographic works, photographic works, computer programs, choreographic works, drawing, in some cases the databases, and of course the computer programs. Computer programs are protected according to the article 64 bis of the Italian copyright law, because we treat the computer program as a text. So we don't protect the computer program by itself, but we protect the code that is in the backend. So the object code, the source code, the programming code. This is the differences. These are the part of the computer program. We protect the code of the program, the source code, the object code, and in some cases, we can protect also the proprietary works. Of course, the trade secrets and the confidential information. They must meet the requirements of secrecy, economic value as a secret, and the appropriate measures. So you have to demonstrate you provide an effort to keep secret this information. Transfer of knowledge could be gained using different protection, like public domain. So the distribution is public disclosure. Secrets. The transfer is possible when we have a secret, but it's really expensive and risky because we have to sign agreements. Third parties should be excluded. And patent, the transfer is of course possible, safe, and cheaper. Respect the secret, for example. And we can protect your idea. This is a concrete example. In the bottle of Coca-Cola, we have the trademark, Coca-Cola. We have a design protected, the bottle. And we have a secret. The recipe is nowadays a complete secret. So that's all. We have some questions.
Thank you so much.
Thank you very much for attending the course. We have a question from Vincenzo Massimiliano Vivenzio. Can we consider utility models similar to innovation patents as Australian ones? Yeah, it's quite similar. And we have some. So Marco Dautai. Stupid questions, and then there is no stupid question, Marco. Every question is important. Since I do not have any knowledge about this topic, can I obtain a utility model and in the meantime ask for a patent registration? Yeah, you can. If you want, you can protect your product with a utility model, and if you have the if you meet the requirements, you can also fill a patent registration. You have to fill each registration, the utility model registration and the patent registration, in the same time. because if you fill the utility model first and the patent registration in a second time, the utility model registration could be prior art. So the office could oppose this previous registration of the utility model, and you risk to invalidate your own patent. So you have to fill in the extra time, same day, same moments, the two registration. But yes, of course, it's possible. The slides by email, yeah, we could provide it. I'll ask to the office. Diego Arellano asked for which is the process of copyright registration. How many categories of sector exist in the Italian regulation? What's the main institution regarding to IP in Italy? The process of copyright registration. So copyrights could not be registered. You gain the copyright rights just for the creation of the artwork, but you can fill a registration, in particular in some entities, Italian or international. In Italy, the most famous is the SIAE, Società Italiana Autori Editori, Italian Society for Editors and Authors. You fill the registration demand with your artwork, like a photo if it's a painting, for example. You fill the demand, it's immediate because you fill the registration demand and they act for protecting it. But the SIAE, like other mandatory entities, is not an institution who gain you the copyright rights. They act for protecting your copyright rights, but copyright is gained by the creation of the artwork. For example, if I write a book today, I assure myself I can demonstrate there is, I remove the presentation, so, okay, so we can see each other. I write a book, I assure myself I can demonstrate the book has been written today, so May the 10th, and I publish it or I keep it secret, but I can demonstrate I wrote the book today because there's this registration of this talk, and I can demonstrate the book has been written today. So the artwork is my creation, and I can demonstrate it was created on May the 10th. Tomorrow, one of you acquire my book, my manuscript, and publish it. Can I act against you for the copyright rights I own? Yes, of course. I can act for protecting my rights, like the authorial rights, but also the exploitation, so commercial use. And I can act by myself, or otherwise, I can ask a mandatory agency or an institution like CI to act for protecting my rights.
Okay, thank you. Thank you so much.
You're welcome. Elaine, how can we protect the patent utility copyrights overseas? For example, how can we make sure a patent in country X is not being replicated in country Y? In that perspective, due to mainly political reason, how can we ensure the unbiased decision by the designated office, considering several challenges, one of which politics? Really interesting question, Elaine. How can we protect the patent utility and copyrights overseas? We can fill an application for every state, every country, when you want to protect the invention. You can fill an international application using, for example, the PCT procedure. It's a specific procedure. And you can fill an international application to protect in every nation in the World Intellectual Property Office territory. You can fill this application. But if you not fill an international application, there could be a problem protecting your patents, but not but there's no problem on patenting your invention in other states. So the patent protected in Italy gain you the rights not to replicate the product in Italy. There are some cases, most of all in China, where some protected design, like car design, were not recognized by the Chinese juridical court. So there are some protected design for BMW, and they lost some juridical controversial in China because the court doesn't recognize the similarity of the shape of the car, of the Chinese car, from the European German car. So that could be a problem in the protection, in the replication. So when you have a specific product that could be replicated easily, the better way is to fill an international application. Of course, when you fill an application for a patent in a single country, like in Italy, no one will fill an application for the same patent in another country, because, and Dr. Fanti will show you in the next hour, the previous patent, your previous patent in Italy, for example, should be examined by the USA office, okay? When someone fill an application for the same patent, they look for international patent, they see your patent in Italy, and they told the new applicant the invention doesn't meet the requirements of novelty, for example. There's no new invention because there's already a patent. One last word. As we as researchers produce science and knowledge that can be used to produce commercial business or products, how much time after to publish an article or thesis we have the commercial rights? Oh, that's a really, really interesting question. That's the first. I'm an attorney. I work at the Scuola IUSS in Pavia, and I'm in charge of the knowledge transfer office nowadays. The first problem when we want to protect an invention is the previous publication made by the inventors, by the authors. Because when you publish a paper and describe your invention, this paper is state of art, is part of the state of art. So when you fill the patent for the invention you describe in your publication, the patent doesn't meet the requirements for the novelty. In particular, in Italy and Europe, if you publish before patenting, the patent will not be granted. In some cases, like the United States, you can publish and fill an application for patent in the next 6 months. And there are some cases in other countries, but in Europe, if you publish and disclose your invention, you can't patent no more. So if you have some invention or ideas, first of all, talk with your knowledge transfer office or technology transfer office or your university office, because if you publish and disclose your invention, the invention will not meet the requirement of novelty. So be careful.
Thank you so much.
You're welcome. I see there's Dr. Jacopo Fanti already connected.
Yeah, I'm here.
Hi, Jacopo. Nice to meet
Hi,
you.
good afternoon. Can you see me?
Yeah, we see you.
Okay, great. Okay.
I'll assign you the cost. Okay. Now I think you can share your
I can share my screen. Okay, can you see? Let me know what you can see.
Just the camera.
Nothing?
I'm sorry. Okay. Can you see the screen?
Now you can see.
Do you see the cover? So patents and prior art search the right way? Okay, great.
Yes.
So if you agree, I don't know whether you want to have a break or can start right now. Maybe we can finish a bit earlier. Maybe I don't know what you prefer.
I agree. If there's no opposition,
let's finish early.
Okay, great.
Okay, perfect.
So I start right now, and then we can end earlier. Okay. So first of all, nice to meet you. I introduce myself. My name is Jacopo Fanti, and I work for the Knowledge Transfer Office of the University of Bologna. I am the head of the new entrepreneurship unit. So basically, starting from last October, I'm in charge of coordinating an office composed by 10 people, and we try to support the creation of startups and spin-offs. But back in the days, I was more focused on protecting the intellectual property stemming from our researchers. So today, the topic of my presentation is related to prior art search and how you could exploit this approach, this tool, in order to better focus your research activity. So you have already seen the presentation about what is a patent, just a brief recap. So a patent provides you with exclusive right for an invention. So it's an exclusive right to a product or process, and the period of protection of your invention is granted for up to 20 years, usually. And in return for this protection, you can disclose, the holder has to disclose the invention to the public. So sometimes a patent is considered as, let's say, a contract between the applicant and the society, because I have a let's say, I know that a lawyer could die in this moment hearing what I'm going to say, but we can say that you have a sort of monopoly for that invention, for the production of that invention, even though we call it exclusive right. But you can be the only one that can produce or sell the product, but in order to exploit your invention, you have to disclose to the public so others can build on that on that knowledge and produce and develop maybe new products or services or processes. So this is a sort of contract between the holder of the patent, the applicant, and the society. The society can grow thanks to the fact that you disclose your information to others. So the role of the patent system, we can say that is to encourage technological innovation and promote competition and investment, since the information is available to the wider public, and to provide information, of course, on the latest technical developments that occurred in the society, and then to promote technology transfer. So this is the important role of the patent system. Thanks to these rights conferred by the patent, you can make, use, distribute. You already seen this, but I think that it's important to have a brief recap around these rights that you can have. And of course, the patents are territorial rights. So the exclusive rights are only applicable in the country in which a patent has been filed. Type of patents, you already seen something about this, but we can have process patent, product patent, or second use patent. It depends on the nature of the research result that you have. So under a process patent, the patent is granted for a particular manufacturing process, usually, and not for the product itself. And any other person can produce the same product through some other process, modifying the various parameters. And in case of product patent, this is an exclusive right given to the original inventor of the product, and this means that no other can provide the same product through the same or any other process. This is important. And the second use patent is generally used in medical field, and it claims the use of an already known substance or combination of substances for a new, usually therapeutical application. So this is these are brief highlights of the main type of patents. What exactly can be patented? You already talked about this, but in order to file a patent application, it is important to underline the requirements that were underlined before. So it has to be new to the world. An invention, in order to be patented, it has to be new to the world, so not available to the public. It has to be inventive, so not obvious, and it needs to be industrially applicable. So when an invention is new, when it is not part of the state of the art, and the state of the art means everything made available to the public before the date of the filing of the patent application. So we said that an invention is new if it is not part of the state of the art. But what does it mean, this term, state of the art in particular? State of the art means that, I mean, it covers everything that has been disclosed through written description. For example, you cannot publish your PhD thesis. Otherwise, you cannot protect your invention. Also, a scientific paper could be conceived as a disclosure of your invention. So in case you already published a scientific paper related to your research result that you are developing during your research PhD course, probably you are not in the position to file a patent application claiming that research result, because you already made it available to the public since you published the scientific paper. And this is also valid for patents. If you already, if a patent already anticipate what is your research result, then you do not, your invention is not new. Probably your research result is not an invention at all, because someone else already developed that kind of solution, of innovative solution. So written description, in case you made available to the public through written description something, it means that the content is already state of the art. And so the content is not new. Then we have oral description also, through a graduation, for example, or a seminar or a workshop in which you present your research result. Also in this case, you cannot be available, you cannot be in the position to file a patent application since you already described your research result. And also by use, I mean, if you have a prototype of your technological solution and you show the prototype to a third party, that could be a company, for example, because you want to receive some feedbacks about your prototype, well, in that case, this is a disclosure made by use. And so this disclosure constitutes state of the art. So also in this case, you could not be able to file a patent application since you already presented to someone your invention. This is very important. I mean, of course, this is quite extreme because if you talk to, I don't know, your girlfriend or boyfriend about your research result, probably that could be considered as an oral description of your research results. So it could be conceived as an oral disclosure, but in that case, probably you still have space, you still have room for filing a patent application because the evaluator could not be able to demonstrate that you already disclosed your invention. But that, I mean, in case you involve a company, for example, in that case, probably the risk is higher than your girlfriend or boyfriend. So keep attention. I mean, it is very important to be aware of this kind of issues. And of course, in any other way, you disclose your invention. In that case, also in that case, for example, through a post published on a social media or social network, in that case, that constitutes state of the art. So your invention is no more new and probably you cannot file a patent application claiming that invention. So we have this important concept. In order to file a patent application, the research result has to be new, so it has not to be already part of the state of the art. And when we say state of the art, we mean everything already available to the public. In every way, it has been made available. So prior art, when we talk about prior art, we refer to all information that has been made available to the public in any form before a given date that might be relevant to a patent's claim of originality. So prior art is any evidence that your invention is already known, and so it is not new. So in order to understand whether your invention is new or not, we need to investigate this state of the art, and we need to find the so-called closest prior art to your invention. So prior art does not need to exist physically or be commercially available. It is enough that someone somewhere, sometime previously has described or shown or made something that contains your technology or a technology similar, very similar to your invention. So we need to focus on the prior art. We need to investigate the state of the art in order to be aware about our invention and the room that we have in order to file a patent application. So we need to conduct patent searches, for example. I mean, investigating the state of the art means launching searches on Google and so on, because as we saw, we need to investigate all the information made available to the public. But in particular, since I think that you are already familiar with the, let's say, scientific part of the story, I think that you already know the literature, the scientific literature related to your invention. But usually a researcher does not investigate on patent databases. So it is important to add this part of the story, because if you only investigate and analyze the literature, you are missing a huge part of the story in relation to the state of the art. You are missing information. So we need to launch patent search. And the importance of launching patent search is also before starting a new research project. Because if you are starting from scratch something, you need to supervise the state of the art in order to find and be aware of what is already available there. But also, in case you achieve a result, You need to investigate the state of the art in order to understand whether your invention is patentable, whether it is new or inventive, and if it has an industrial application. So you need to find document related to the closest state of the art of your invention, so to the closest prior art of the invention. This is very important. So in the next minutes, we will see what does a patent look like, why should I make a prior art search, where can I find the information, the patent information, and where I can find, and when should I make the search, and how can we conduct these searches? What does a patent look like? I mean, this is the original patent, as you can see, from 1891 for a toilet paper roll, showing the correct rolling direction in case you have adopted. So this is a typical example of a patent. In a patent, you can find bibliographic information. So who applied for the patent, who invented it, the technology class, which is very useful for searching, for example, and an abstract. A patent is composed by an abstract around 150 words, and that could be also very helpful in case of searches. Then you have descriptions, as mentioned before. So the description contains a full and detailed description of the invention, so that other people can understand, first of all, can understand the technology and replicate it. So this is very important. Then we have the claims, which are the very heart of the patent. And then we have drawings that show the patent content. You can see here the cover page of European patent, in which you can find priority date, which is the date of filing, the publication date, and so on. And then we have a document number and the design states in which the protection is valid, then the applicant, the inventors, and so on. We have a title, classification, and abstract. This is an example of an Italian one, an Italian patent application. You can see there the patent number, the applicant, the title, and the inventors, for example. So bibliographic information, of course. Then we have the description. And the description is the most important section from the technological point of view. It has to be clear, of course, and sufficiently complete for a third party, for another subject to be able to reproduce it. So this is a requirement foreseen by the law, as we were mentioning before. And yeah, in this case, the inventor, for example, specifies how that product or process differs from any other prior art. So it contains a very detailed description. This is an example, a typical example of the structure of the description. So the invention which is shown is from the UK, a patent application filed in 1930, but it's very easy to understand because we have the prior art, and the prior art in this case, the tip is a teapot with one spout. Then we have the drawback of the prior art. We need to describe the drawback of the prior art, and in this case, it's the time-consuming activity that you have to put in order to fill a cup, for example. So we have a problem to solve and we need to describe it. And the problem to solve is reduce the filling time of a cup of tea or 2 cups of tea. And so we provide a solution. And our solution in this case is to provide a second spout to the teapot. And the advantage of the invention is the time needed to fill the multiple cups is reduced. This is the typical structure of the description of a patent application. Prior art, the drawback, the problem to solve, our solution, and the advantages of our solution. Then we have another section, very important section of the patent, which are the claims. And we have a pyramidal structure in this case. And the claims define the legal scope of the patent. They define the area of technology for which patent protection is requested. So the first claim in any of the above sets is called the independent claim. And all the other claims which refer to the independent one are called dependent claims. The first include a broader definition of your invention, leaving out any and all unnecessary options. While the second, for example, include a claim that defines your invention with as much specificity and with every other option you can think of. So in this case, for example, we have a first description which describes a sandwich in its very core structure, and then we add, thanks to the other claims, we add the details. So we refer to the first one, adding details. This is the typical structure of claims. And the patent claims indicate the scope of the protection. It's the very core, it's a very legal part of the patent. Drawings. Very often, as in conventional scientific literature, patents contain diagrams or other graphics concerned with the invention. So I think that they are very helpful in order to better understand an invention, a technological solution. And in this case, you can see some examples. We have the first Lego patent, toy building brick, filed in 1961. And then we have a sailing bicycle, for example. We have the beer umbrella, which is an umbrella for a bottle of beer. Then we have a gerbil shirt, so you can move around with your gerbil inside your shirt, and so on. So the drawings helps in describing and providing information about your invention. Then we have the examples, specific examples of how to practice the invention. Also in this case, examples are very important because other people can replicate these examples, and they can have an idea of what you developed, and they can replicate it, and building on that, we can provide progress to society because we can build on already available information, already available knowledge. And then, of course, each patent has a number, and the application number is assigned by the office where the patent application is filed, and it is a unique identification number. And of course, when the protection is extended to other countries, new filing numbers are given to the same technology. All the patent, maybe this is important for you, all the patent applications related to the same invention are called patent family, because a technological solution, an invention, can be protected through several patents, since you have usually, in general, you have one patent for one country. When we talk about the several country-based patents protecting the same invention, we call the overall patent application, we call them patent family. But let's talk about why should I make a prior art search. So we saw what are the main features of a patent application, but still we need to understand whether we should make a prior art search, why we need to investigate the patents already available. Well, why? Because we need to avoid reinventing the wheel, basically. And literally, in this case, the technology transfer agency Provendis, which is a German one, estimates that 25% of all German R&D investment is wasted by duplicating R&D that has already been done. So, and why this happens? Because people that are developing new inventions, new solutions, are not aware of the state of the art of their technological field. So we need to avoid reinventing the wheel. And in the example shown on the side, the application relates to the technical problem of the excessive wear or even explosion of aircraft wheels due to the high acceleration when touching the ground. And the proposed solution provides for small pockets on the side of the tires that make the wheel spin, so in the wind, without the need of an additional electrical motor. So this invention had already been made in 1931, as you can see there. So someone in 2002 filed a patent application already available by almost 100 years. So we need to avoid to reinvent the wheel. So we need to be aware of what is already available. And we need to investigate the patent database in order to be updated. Because patents are all around us. There are a huge number of patents covering almost every product that you can buy. So patents are of interest for everybody. So here are some examples of patents in 3 different technical domains. As you can see, the superconductors, which were very important, very famous, very known, and very trendy during the 80s and 90s, now have dropped. And toothbrushes, for example, are increasing, or bicycles, patents related to bicycles, for example. And as you can see, we can count over 6,000 patents related to bicycles, for example, in some years ago. So patents are all around us. This is important to understand. And even though something could seem a traditional product, probably someone is still finding new ways of producing or adapting this technology. So it is very important to be aware of patents. And in some technical fields, approximately 80% of the information that can be found in patents is not available anywhere else. So even though you investigate the scientific side of a technological field, you are missing potentially the 80% of the information in case you do not launch some patent searches. So this is very important. Again, there are the number of reasons why most patent documents also, I mean, as you can see here in the picture, you can also find many great solutions for free. In case you, I mean, this is very important since I usually support research groups that wants to launch or create a new company, for example, a new spin-offs for stemming from the university. It is very important to know that sometimes you do not need to have the great idea, because the information, new ideas are already available, because in the patent database you can find many great ideas for free, because probably the patent is no longer alive because people haven't paid the fees in order to maintain alive the patents. This means that you cannot protect the same invention claimed in that patent, but you can exploit that invention, that technology claimed in the patent commercially. So be aware also that if you investigate the patent scope, maybe you can find a lot of interesting ideas, and maybe you can start thinking on exploiting those ideas. So this is another, I think, important take-home messages from today, probably. So why we need to investigate the patent databases? Because you need to supervise new technologies, you need to be updated about the results coming from others, research groups or company. Then you need to you can find solutions to technical problems in case you are looking for a solution. You could avoid unuseful information. And also the why is that if you are starting a new project, a new research project, being aware of the state of the art of that technical field could guide your research approach in a smart way, avoiding reinventing the wheel, as we saw. And in addition, you can be in contact with important commercial opportunities in case you want to explore also this part of the story, which is the entrepreneurship part of the story. I think I have a problem with the presentation at the moment. I have a problem with Microsoft PowerPoint. I think it is freezed. I will try to restart Microsoft PowerPoint. Sorry for the technical problem.
In the meantime, if someone has a question or clarifying information to ask, feel free.
Of course.
There's a question from Diego. If we use software, artwork, or books without a legal license, for my own knowledge or science diffusion without an economic profit, there isn't a punishment. What are them?
I'm sorry. I'm trying to solve the problem, so I wasn't able to listen to the question. Let me check whether you can see.
I'll ask instead of you. If you use software, artwork, or books without a legal license, there's a copyright infringement in this statement. So
no, it depends. I mean, in case you find a technology, a patented technology available, for example, in a patent database, and the patent is no longer alive, in that case, those information constitute state of the art, which means that those information are completely available to the public. So you can use exactly the same content presented in the patent, also for commercial purposes. But of course, you need to be aware that there are no other patents, for example, or no other IPR covering and protecting that idea. But for example, usually when you find a patent no longer alive because the inventor hasn't paid for the fees, for the maintenance fees, in that case, it doesn't mean that the invention was not promising. It's just a matter probably of timing, of resources for inventors to develop the invention and so on. So once the patent is lapsed, so is no longer alive, you can use the content.
That's regarding the patent. And what about the software and books?
Books and software, of course, are protected by other IPRs, which is the copyright usually, and the copyright is, let's say, the legal protection provided by the copyright is alive for till the death of the author, and also for 30 years or 40 years after the death of the author. So in that case, for example, it's software, you cannot just take the software itself and use it because it is covered by copyright. And the same is foreseen for a book or a poetry or a painting and so on. So this is these are work of arts covered by different kind of IPRs. But in case of patents, you can use this available information and you can exploit it. Of course, I mean, it's quite obvious. In that case, you cannot file another patent application claiming the same invention because that is part of the state of the art. So you cannot file another patent claiming the same thing. But, and this is a major problem in case you are looking for investments, for example, because if you go to an investor and say, okay, I want to run my new startup and I'm developing this kind of technology, he will ask you, do you have any protection for your technology or not? And you cannot say I have a patent because a patent already existed. So, but this doesn't mean that you cannot exploit it. So you need to, you could, in theory, you can use it.
Thank you very much. There's another question from Vincenzo. Is it possible to patent a nucleic acid sequence, DNA or RNA, and what are the limits?
Maybe you can better answer, but if you want, I can, since it's not more related to the topic that you covered probably before my presentation, but in case I can answer. Let me know what you think.
If you like, you can answer.
Yeah, basically, I would answer. I mean, every time we need to be more specific. We should, let's say, run a due diligence, and so we need to study and analyze the research results. So it's not very professional to provide a general answer, but in this case, my general answer would be, yeah, we could try to file a patent application related to the nucleic acid, the sequence, but the content of the patent application is the application. It's not the product itself, it's the use that you make of that sequence. In that case, you are trying to protect a specific application of something which already exists. So the inventive step that you are providing is linking something that already exists with a new application. That's your contribution in terms of inventive step, let's say. I'm really sorry, but I cannot fix this problem. I have a problem with PowerPoint. It's crashing again. I need to close the program, but then it crashes again. So let me check, but if you have other questions, I'm here to answer those.
Any other question? Maybe I can check if it's possible to share the slide from.
I try to close other programs. Maybe I'm too. I will squeeze the rest of the presentation in a few minutes. Okay. Can you see?
Yeah.
Can you see the presentation? Okay. I will go slowly to the point we were before, because I'm a bit worried about the memory of my computer in this moment. No, I think that we have a problem with the 28th slide because it's crashed again. It's really strange.
Let's see if I can share it.
Maybe, yeah, if you have my presentation.
Yeah, I'll try it.
I'm really sorry. I don't know why it crashes all the time.
Don't worry.
Maybe I can skip the 28th. I'm afraid it is something that matters with that.
So let's see if I can share it. So the slide was this.
I can.
Okay, let's try this.
I can try for the last time, then I give up. Can you see it?
Yeah.
Okay. So here is a graph showing when we should conduct a patent search. So before starting your activity, your project, when you have your idea in order to be updated on what is already available, then during the project development, because you need to be always aware of what is going on. So checking the patent databases can give you an idea of what others are doing, because they're filing patent applications related to your technology or your technological field. Then once you achieve a result, a research result, you could investigate the patent databases in order to understand whether there is room for filing a patent application. And till 18 months after filing a patent application, you could be interested in launching searches, because for the first 18 months, a patent application is secret. So you need to keep searching for new patents that are made available. So where I can find patents, there are many databases online, of course. Some of them are for free and other ones are subject to payment. A SpaceNet, for example, is a patent database made available by the European Patent Office, even though, of course, it integrates also patents coming from other countries. Then we have the USPTO Patents Office, so basically the US Patent Office that provides a service in terms of a patent database available to the public. Then we have the Italian Patent and Trademarks Office, Patent Scope, and so on. In particular, there is a commercial database which is called Orbit that I know your institution pays for, so you can use it in order to launch these patent searches. Of course, one important feature of the patent databases is the coverage. It is important to have a wide information related to patents filed in also faraway countries. So we need to have a strong coverage for each patent databases. As I mentioned before, there are free and commercial. The main difference is that in the case of a free database, there is the search that you can launch is related just to the title and the abstract. And this is a very strong limit, and we will see why. And also in general, free databases has less complete information related to a patent. And so payment databases, of course, provide a better service. And as I mentioned, you can use Orbit, which is a strong patent database that we use, for example, in order to launch prior art search when a research group asks for in order to understand whether something is patentable or not. We use it. We use Orbit, the patent databases, and you could launch some searches, preliminary searches on that tool. SpaceNet, as I mentioned, is the patent database made available by the European Patent Office. It is European, of course, but it has a worldwide coverage, and you can find patent applications, but also already granted patents and patent families and so on. So is very user-friendly, and I suggest you, in case you cannot use Orbit for some reasons, probably a SpaceNet is the most useful patent database available for free. Again, I have some problem with the PowerPoint. I'm really sorry for these technical problems. I cannot understand why. I mean, it's just a presentation. It is not a very heavy program, but still I have some problems. It is freezed. Maybe it's the sharing of the screen probably that is creating some problems. I try to interrupt the sharing. Let me see whether I can fix this. Really strange. I'm really sorry. And okay.
Let's try if this works.
Okay. I'm not sure. I'm not sure I have the control. Okay. Okay, so this is the home page of a SpaceNet patent database. And here you can see how to launch an advanced search. And then we have Orbit. That is the tool that I was mentioning, very professional. It has a lot of information, value-added content. You can also launch some analytics, let's say, because in some cases you could be interested, for example, I give you this example. You are conducting your research activity in a field and you want to understand who are the top players, let's say, in terms of inventors in this field. In this case, you could be interested in launching some analytics on Orbit, trying to, let's say, find out the most recurrent inventors in your technological field in order to get in touch with this person that could be a professor, but also a person coming from the industry sector, from the industrial sector. So in that case, I think that probably this is an important feature of Orbit because you can probably you can find a person that, for example, filed 50 patents related to a technology and you are developing your research around that technology. So probably getting in touch with this super top player that you have found out thanks to the patent database could be a good strategy for your impact factor, let's say, for your publication and so on. So this could be a lead. Or another important aspect could be understanding what are the companies that are developing research and innovation in a particular field, because maybe you could be interested in, let's say, find some sponsorships, for example, for your research, or getting in touch with a company in order to create a collaboration. So I think that the prior arts, what we call prior art search, but also patent searches, can provide you with several information. Of course, the, let's say, definition of the perimeter of the state of the art of the technical field in which you are working and studying and conducting your searches, your research, but also in terms of top players, in terms of physical person or companies or institutions that are developing research in your field. Of course, there is the scientific aspect, so you can also investigate the literature word. But as I mentioned before, as I showed you before with that slide, the 80% of information is available only in the patents. So of course, there is a publication that refers to a patent and vice versa, but there are many information contained only in the patents. So it is important to be aware of this aspect and to understand how you could exploit these tools in order to become a stronger researcher. So this is an important aspect, I think, of today's presentation. Here you can see the home page, let's say, of Orbit. And also in this case, you can see that you can launch searches by keywords or classification. So you can filter through a code of classification, and then you could search for applicant or inventors if you are interested in understanding what a specific person is doing. You could find out what are the patents filed by this person, and then you could launch searches for countries and so on. I think that in general, in order to be aware of the state of the art of your technical field, you need to use keywords, of course, maybe filtered by a classification code. What about chemistry? We have also other databases. I suggest you Reaxys, because thanks to this tool, you can also create the chemical structure search. So I think that this is very important for this specific scope. How can I conduct the search? I already mentioned that there are many different types of search, but by keywords is important. I mean, before starting a keyword search on a patent database, you need to be aware that patent writing is very peculiar for different reasons. In particular, because if you think about it, once you file a patent application, that information is available also for others. And put yourself in the shoes of a company. I have a new product, I want to protect it, so I need to file a patent application. But after 18 months from the filing, those information are available to the public. So others could potentially copy, let's say, my invention. So I need to write my patent application in order to not be found on patent databases. This is a typical strategy that a company uses while writing a patent application. Of course, I need to write it down, I need to describe the invention, but I can use a peculiar style in my writing in order to not be found in the patent databases. So others cannot be aware of what I'm doing. And my patent is not the first result for each search that you launch, for example. This is a typical strategy. So I need to hide from a competitor. So I use a peculiar writing, a legal writing, in order to hide from my competitors. But also because if I use correctly the legal style in my writing, probably I'm broadening the scope of my protection. Because, for example, if a spring, usually in the patent writing, a spring is not a spring, is an energy storing means. And if I write down my patent application using these broader terms, I can also protect more than one product, for example. And so in order to launch a correct search, beware of naive keyword searches, because patent jargon is used to broaden scope of the patent, and sometimes the applicant doesn't want to be found. In this case, you can see the nail, typical nail. A patent claiming a nail probably will never mention the word nail or screw. A nail in general is a fastening means, for example. So be aware of this typical and peculiar style of patent writing. So my suggestion is of course, use keywords, but use a lot of synonyms, for example, because even though you think that that term is the closest term to your technology, probably it is not in terms of patent, in the patent framework. So use a lot of synonyms and use in particular the classification, because the classification is not defining the classification, is not in charge of the applicant, but is in charge to the authority. The authority, the patent office, is in charge of attributing a code of classification to your invention. So the code of classifications are reliable as a filter for your searches. So use a lot of keywords, many synonyms and so on, and filter by a classification code. I think that this is very important. And in particular, I suggest you to use the cooperative patent classification, the CPC cooperative patent classification, which is worldwide recognized. And so you can, this is an example of the classification, which is very detailed. And I think that this is very useful for launching searches, coupled with keywords, because as you can see, it starts from A, B, C, and so on, but then it comes to C07, K2, 3, 1, and so on. So it's very detailed. So you can find basically probably a really close code to your technology that you can use to filter the keywords that you are putting in the advanced search box. So a possible path in order to exploit this information that you can find in the patent databases is to define the information you need, select the database that you will use, identify keywords, synonyms, and so on, and classes and code of classification, and search, launch many searches, and collect documents step by step. You need to find the closest prior arts. You need to find the more similar patents already available to your technology in order to understand whether your technology is patentable or not. And you need to launch many and several searches in order to reconstruct the perimeter of the state of the art of your technical field. Then you, of course, you need to narrow this bunch of documents and select the final documents that you can consider the closest prior art to your invention. So some warnings related to this. If you do not look for prior art, others are doing it. So avoid reinventing the wheel. Be aware of what is already available. This is very important. And do not ignore evidence that you do not like. I mean, the purpose of a prior art search is to find out evidence, also evidence that you may not like. So be brave and do not worry, and find out everything that could be useful for you in order to better understand the technical field in which you are working. Of course, you should update your prior art periodically as you develop your idea, since information is always coming out, so you need to be updated. And no prior art search is conclusive. I mean, there is not a perfect prior art search. It's something that is always in construction, and so you need to launch it periodically. And you should not be scared of what is coming out, because I think that be aware is a duty for you in order to avoid wasting public money, for example, in developing a research that is already known, for example. So in general, as you probably already know, do not publish something before having protected it, in case, of course, the research result has a commercial potential, let's say. And do not sell, of course, any products that incorporates invention your invention or your research results. And in general, once you interact with companies or third parties in general, also other research institutions with which you are sharing some information, sign a non-disclosure agreement. This is very important. You need to protect the exchange of information related to your research result. And in general, if you are interested in protecting your invention in order to start with the, let's say, technology transfer activity or to the license, for example, you could be interested in licensing this invention of yours, seek professional advice, ask to your KTO, TTO, tech transfer office, and so on. Start immediately, because they can provide you with information and they can provide you with support and they can guide you doing the right thing. So, and of course, file before anyone else does. Otherwise, your invention is no more new and you cannot file a patent application. So I had a case study related to Orbit, but it's very textual because I wasn't sure about the technical part and so on. So I think that we could skip this. But I invite you to use this tool because it's very, as I mentioned, I mean, it's very important to be aware of the patents. This is an example of a list of results highlighted by Orbit. And here you can find a lot of information. This is an example of a number search, because if you are already aware of a patent, you need to read the patent text. You can launch a search based on the number of that specific patent. But in general, in order to launch general searches, in order to construct the state of the art of your technical field, I suggest you and I invite you to launch searches based on keywords and filtered by classifications. And well, more or less, that's it. I save some time for your questions, but if you do not have questions, I ask to Luigi whether we can finish. Please. Okay.
Regarding free-to-use databases, what is the best one for running patent prior art research, in your opinion?
Regarding the free databases, I think a SpaceNet, probably the one made available by the European Patent Office. But again, I think that in general, when we talk about free databases, the main problem is that you can only search within the title and the abstract. And starting from what I said, so that an applicant is not willing to be found. I mean, when I file a patent application, I do not want that a potential competitor could find specifically my patent application. Usually, I will not put the core information in the title or in the abstract. I will hide, I mean, the core information in the claims because I'm obliged to do it. So if you have a tool that search only in the title and in the abstract, you can miss a lot of information. So I will suggest you to exploit Orbit, since you, as a university, as a research institute, you have the access to that kind of, or at least your KTO has the access, and you could interact with your KTO on the modalities on which you can use the tool. But in case you cannot have access to a payment database, of course, a SpaceNet with the great prescription, the great warning that I already gave you.
Thank you very much. There's a question regarding the access to Orbit, but I'll ask in private.
Okay.
If there is any other question.
I am aware that, I mean, intellectual property in general, patents, patents databases also are not common knowledge in the research field. I have a PhD myself, and when I was studying in my PhD course, I wasn't aware of all these informations, but I think that it's very important to start with the right foot your academic career. So I think that courses like this are very important because you can develop some, at least you can have some information, and then you can be aware of who are the people to contact in case you have some doubts, for example, in interacting with the company, in publishing something that you think that could have a potential commercial. So before doing that, it is important that you ask to your KTO support, because maybe you can file a patent application protecting that research result, and then you can exploit it. I mean, it is important for a university nowadays to develop the third mission of the university, which is impact. So, of course, a scientific publication can have an impact, but usually a scientific publication have an impact limited to the scientific sector. In case you have something interesting that could have a broader impact also for the society, also for the industrial sector, it is important that you try to protect it, and then you try to transfer it to the industrial sector. And to do that, you need to not waste the information publishing something that in that case is available to third parties. You need to protect it and then to transfer it with the correct ways that your KTO can guide you through. So this is a general consideration, but I think that since I'm working in this field for not so many, but some years, I think that it is important to start with the right foot. So PhD is the best target that we should have in order to transfer this information.
Thank you very much, Jacopo. There is no other question. They are thanking you for the course. Thank you very much, Jacopo, for joining this course. Thank you all the attendees. And we hope you enjoy the next session that will be held on Wednesday 17, same time, 3 p.m. And we will talk about business plan and venture capital investment funds.
Okay, thank you for having me, and good luck with your research and your academic career for the next years.
Thank you very much. Have a nice day.
Have a nice evening. Bye. Bye-bye.
Bye.
Thank you so much.
Thank you so much
you.
for the
Bye-bye.
presentation and everything.
Yeah, thank you for everything. It was really, really important and relevant knowledge.
Thank you.